If you do not want to be recorded, please go ahead and leave this Zoom call. We will also email all of you minutes and notes from the session on this evening. So again, if you do not wish to be recorded, because this will be a recorded session on this evening, go ahead and leave the chat room and we will definitely email you at the conclusion of this session. I'm excited because there's information that we definitely need to share with you all. Are you hearing me okay? All right, and so on this evening, what I would like to do is have the attorneys share information with us that will be beneficial for all of us here. All right, thank you so much for confirming that you can hear me. So before I go any further, hello, Mr. Kirk Batson. I do see DC Housing Authority officials on the line. Thank you so much for joining us. And so guys, if you have questions for officials from the DC Housing Authority, they are here. They will be answering your questions as well. And so at this time, I just wanted to find out from you, Mr. Hessler. Let me go ahead and have you to unmute yourself, if you will, Mr. Hessler. All right, let's see. We're having some difficulty here. Give me 1 second, guys. All right, let me do this. Mr. Hessler, can you unmute yourself, sir? All right, give me 1 second. I see your lips moving, but I don't hear anything. Give me one moment, Mr. Hessler. All right, give me a second, guys. Okay. All right. I am not sure why there is no audio coming from you. Give me a second here. All right, so let me do this. Let me see a comment. Thank you so much for that. Mr. Billy, thank you so much for that. All right. All right, go ahead and try it now, Mr. Hessler. All right.
Can you hear me?
We can hear you now. Thank you so much.
Well, good evening.
Good evening and happy Wednesday. All right, so Mr. Hessler, before we get deep into the conversation, I just wanted you to give an introduction of yourself, the firm, who you are, a little bit of information that you're going to share with us on this evening, if you will, if that's okay, sir.
Absolutely. Well, first of all, I'd like to thank you for giving me your card, those months ago, pre-COVID, in the hallway of the courthouse when it was open. And so here we are today. I'm part of a larger team, and one of my team members is Billy Cannon, who actually has put together the PowerPoint that we will be using today. We are part of a landlord-tenant practice group. The firm is Offit Kerman. We specialize in landlord representation, and we each bring a little something different to the table. I'm probably the oldest group, so from a diversity standpoint, they let elders play. Billy is chair of one of the groups in our firm, and he actually is down in the weeds on the statutory and the regulatory specifics. My contribution is the actual practical aspect, having handled many cases for the Housing Authority, for private landlords, et cetera. And our group also includes a number of other really, really fine folks I'm happy to work with at Offit, Jennifer, Gwen, and Brian. For diversity and fair housing training, we've got Reve Walters. So we are a group. You're going to see two of us today, Steve and Billy. And I'd like Billy to share a little bit of his expertise, what he brings to the table. And I'm going to give him credit where credit is due. The PowerPoint is primarily his. I will chime in from time to time with questions, practical advice, and hopefully a little bit of humor in a rather terrible situation. Billy?
Well, this is Billy. If you know Steve, you know that he will chime in with humor, and that's what makes him such a good person to practice law with. In addition to obviously his years of experience, what I like to tell people is that when Steve joined our group a few years back, we acquired probably the best practitioner in the city, and all of us are able to benefit from the wisdom that he brings from his years of practice. He's able to recall cases and provide strategy without even doing a lick of research, given how long he's been here in DC and how much he's seen it change. I'd like to echo what he said and thank everyone for joining the call tonight, and thank you especially Carissa for asking Steve and our firm to present to you. Now I'm going to try to share my screen. I'm not exactly sure how this is going to go. Okay, Chris, it says that the host has disabled attendee screen sharing. I don't know if, Carissa, you want to share the presentation, but I have it and I can share it if you can allow me to do that.
All right, go ahead and give it a try now, Billy. Sorry about that.
All right, can everyone see? Got the first slide of a PowerPoint presentation there on the screen, which says DCHPA update on COVID-19 laws. All right, terrific. So let me move through here. From a real basic standpoint, what I want to do with you guys tonight is just try to cover, look, there's been a significant amount of legislation that's been passed since the middle of March, when the city went into pandemic mode and closed down. And what we have most recently is we have the Coronavirus Support Emergency Amendment Act, as well as some clarifications to that. I'm going to go through some of the key provisions of that law, and I'm going to talk with you guys a little bit about what you need to know as landlords in order to make sure that you're complying with the law and that you're doing what you need to do to offer payment plans, to clean your properties, and to make sure you're not taking improper rent increases. So here's our background. March 17th, the council passes the COVID-19 Response Emergency Act. 10 days later, on March 27th, the federal government passes the CARES Act, which I'm sure a lot of you have heard of. There are certainly ramifications associated with the CARES Act for any property that is part of the HCVP program. Those properties are deemed to be federally backed, and therefore were covered by the eviction moratorium in the CARES Act. On April 10th, the council, or what became law in the district, is the COVID-19 Response Supplemental Emergency Act. May 13th, the Coronavirus Omnibus Emergency Act. May 27th, the Coronavirus Support Emergency Amendment Act. And then there were amendments passed to that act on June the 9th. It's important to remember these are emergency bills. They're effective for 90 days. The council has been continuing to meet virtually. Of course, they've been busy with the budget recently, but I would expect that as we continue to move through this pandemic, there may be more bills that come down the line. So I'm going to start with what I think is probably the most challenging section, and that's the section on mandatory payment plans. And I'm going to have to correct this slide. This section is complicated, but during the public health emergency and for 1 year thereafter, landlords must offer a payment plan program to eligible tenants for rent and any other amounts that come due under the lease. So for 1 year thereafter. So during the public health emergency, which began on March the 11th, is currently set to continue through July 24th. But as many of you probably heard, the mayor today announced that she intends to extend it to October the 9th. I'm not sure when that will happen. It will probably happen sometime in the next few days. So for 1 year after October the 9th, as soon as the mayor extends it, a landlord's going to have to make a payment plan program available to eligible tenants. Now, the initial version of this bill said that the payment plan was going to be for rent, for gross rent. That's been changed in the clarification to be all amounts that come due pursuant to the lease agreement. So in addition to rent, if there are other amounts that your tenants pay pursuant to the lease agreement, then those are amounts that you're going to need to make part of a payment plan that you may offer to your tenants. Pursuant to this legislation, the rent payment program shall permit an eligible tenant to enter into a plan for amounts that come due during the program period and prior to the end of the tenancy. Waive any fee or penalty because of participation in the payment plan. The landlord shall not report rent subject to the plan to a credit bureau as delinquent while the plan is in place. And the landlord has to notify all its tenants of the availability terms and the application process for the rent payment program. Now, if you haven't done that yet, if you haven't yet notified your tenants about the availability terms and application process for the program, then that's something that you should really make sure that you are getting to very, very soon. This has obviously been law since May the 27th with clarifications June the 9th. So we're over a month in here. Now, as you'll see as we move through the slides, in terms of the actual ramifications for failure to offer the plan, there aren't really any possibility of eviction or possibility of filing a new action for possession. But in order to be compliant with the statute, notice should be going out soon. Let me pause for a moment and answer. I've got a question here from David Newman, which says, do payment plans need to be offered for 1 year after the emergency ends, or payment plans during the emergency must last up to a year if needed? The answer to that question is both, actually. So the way that I read the statute is that payment plans need to be offered for the time period of the emergency and for 1 year after the public health emergency. Now, those are for eligible tenants, which we'll talk about in a moment. So offering them and making them available, and then whether or not tenants are eligible are two different questions, and they're both meaningful. Second here, the payment plans must last up to a year. Yes, the payment plans, which we'll talk about also in a moment, need to be 12-month payment plans unless the tenant requests a shorter term. There are no limits on sizes of landlord. There were in the May 13th version of the law, but in the May 27th version of the law, those limits were removed. So this now applies to all landlords in DC. Sample notices available. We have drafted some notices for our clients. And Steve and I talked a little bit about this earlier today. We do a bunch of different stuff for our clients, and some of our clients have asked us to draft these for them. Some of us have reviewed versions of these notices or payment plans that have already been drafted. Some of our clients like to do the drafting themselves, but that's certainly something that we could do for anyone on this call if you reach out to us after the call. Let's move on here a second, and I see another question, but I think I'll get to it here in a moment. So let me just make sure. Yeah. Landlords have to establish procedures for applications to these plans by telephone or online methods. By online methods, I don't read the statute to mean that you have to have a Dropbox capability or something like that. I read that to mean just that you need to be able to accept information from your tenants via email. And that's what we've been counseling our clients to do, is to take these applications via email and to make sure that you guys can review whatever they send via email. Applications shall be approved. And here's where we get to the eligibility of a tenant, right? So an eligible tenant is a tenant who can demonstrate evidence of a financial hardship resulting directly or indirectly from the public health emergency. And the tenant has to agree in writing to make payments in accordance with the plan. So that's real important, right? Evidence of a financial hardship resulting directly or indirectly from the public health emergency. What does that mean? Well, one of the things the law says is that the tenants may be required to submit supporting documentation. Just to give you guys some examples of documentation that we've seen letters from employers saying that tenants have been furloughed or have been laid off, that businesses have been closed. We have seen bank statements from tenants in February, which show them receiving, a paycheck on the 1st and the 15th, and bank statements in March, which show them receiving no paycheck or show them receiving a significantly reduced paycheck. We've seen unemployment applications. We've seen letters that say that employees have been furloughed. Tenants are employees who've been furloughed. And so all of those are, I think, examples of documentation which would be sufficient to show evidence of a financial hardship resulting directly or indirectly from the public health emergency.
Lily, can you hear me?
I can.
Hi, this is Steve. If everybody can hear me, let me discuss a little bit the flip side of the coin if you are handling a commercial case. I represent all of the merchants in the South Hall at Eastern Market, and we are now trying to get rent relief from the city government. And the sorts of information that I'm trying to, the tenants are the head count of the people who are allowed to be there, or perhaps their financial records. I'm also handling some commercial cases for landlords, small landlords, because one of the questions was, is there any limitation on the type of landlord or the size of the unit? The type of information that a commercial landlord would ask for would be, are you retail or not? Retail has been defined also to include bars and restaurants. And so the sort of financial and commercial landlord would look for, what is your cash statement? Is there a guarantor? Those sorts of information to see whether or not the tenant is just trying to come up with an excuse, or whether there is a fact or numbers-based reason to decrease the rent, and if so, what would the metric be to do so?
So in terms of these payment plans, and Steve's 100% right, these payment plans are plans that need to be offered to certain size commercial tenants in addition to residential tenants. So one of the things that you need to be aware of here is that so first of all, you have to make every single one of your tenants aware of the availability of the plans. Okay, you have to make everyone aware of the availability of the plan. The plan, if you enter into it, needs to be 12 months, needs to be in writing. It cannot have lump sum payments, and it needs to allow for the possibility that the tenant could pay early, so there's no prepayment penalty. If the tenant seeks a shorter term than 12 months, then that's something that you can offer the tenants. So I think I'm answering most of these questions as they come up. Now, one of the questions here, it looks like from Justin Connor, which I think is a very good one, is it required to be offered to a tenant whose entire rent is paid for by DCHA? The answer to that question, I believe, is yes. You're required to notify even a tenant who is a zero renter of the availability of the plan. However, I do not believe that a tenant who is a zero renter is going to be able to show a financial hardship such that you should actually enter into a plan with that tenant. Moreover, I don't know what that tenant would be asking to pay over time, right? If the tenant is a zero renter and presumably has a utility allowance as well, then what we're talking about is, a situation where, perhaps there are some utility bills that are outstanding that you could enter into a payment plan for, but I don't think that we're going to be talking, or hopefully not going to be talking about a very large sum. For tenants who apply, landlords have to keep applications on file for 3 years, whether they're approved or denied. Landlords must make these applications available upon request to the rent administrator and the Office of the Tenant Advocate. Residential tenants whose applications are denied may file a complaint with the rent administrator, and that complaint will be handled by the Office of Administrative Hearings. Commercial tenants whose applications are denied may file a complaint with DCRA directly. And let me just add a word about how I view these applications. The analogy that I've been making recently is sort of as like a fair housing reasonable accommodation request. A tenant's making a request to you for this payment plan after you notify them of the availability of the plan. Just like a reasonable accommodation, a tenant coming in and saying, I have a disability, I need to keep an emotional support animal in the premises. Just like that, you want to approve the plan if it's warranted. So I recommend coming to these discussions from a place of, let's see if we can get this plan approved as long as the documentation is in place. So here's eligible tenant, the tenant of a residential or small commercial property who has notified the landlord of an inability to pay all or a portion of rent due as a result of COVID-19 and can demonstrate evidence of a financial hardship. As I said earlier, housing provider now includes all landlords. So it's not limited to larger landlords anymore. There's no small landlord exception anymore. In terms of notifying your tenants of the existence of the plan, I would communicate with them in whatever way you normally communicate. So if that's via letter, that's fine. If it's via email, that's fine. Text message. The key, as with most of these things, is to do your part to be what I will call over-inclusive. It's better to contact your tenant in more ways than one in order to be able to demonstrate, should there be a need, that you complied with the requirement in the statute that you notify them. All right, so I'm going to move on from payment plans here to residential cleaning. I think I've answered the questions.
Billy, if I may, let me add one point. With respect to enforcing these obligations, Billy mentioned that a residential tenant could file a complaint with the rent administrator. One of my practice areas is commercial, and I will tell you this. I'm defending a commercial landlord for the first ever complaint made by a commercial tenant, a nightclub, under the Act. And the place for the commercial tenant to complain is DCRA, and DCRA is supposed to forward the complaint for adjudication to the Office of Administrative Hearings. Not only did DCRA say that they were not equipped to do it, OAH said they would not and kicked it back. And so at the moment, if you have a commercial tenant who does not believe that you are negotiating or giving a plan in good faith, there's no place for them to go. And I'm not saying that you should poo-poo the law, but at the moment, there's no way to enforce it, at least on the commercial side.
Well, and I think that fact speaks to, you know, what's going on. I think not only locally but nationally is we have a crisis on our hands. We have lawmakers who are doing, you know, what they think is necessary to respond, but it's all happening very fast. And what that means is that, you know, the mechanisms that are normally in place to handle the adjudication of disputes between parties in situations like this just aren't available. They don't have the ability to do this. I think that, you know, the crisis is lasting, and I think that as it lasts longer, the adjudicatory bodies, the administrative bodies will catch up, and we will see it eventually. But it's a really important point to keep in mind. And remember, you know, these applications need to be kept on file for 3 years, right? So if a plan's denied, then you may not receive a complaint now, but you might receive one in a year and a half, right? You might receive one in 2 years. So something to keep in mind. See a couple questions here that I want to respond to. If the tenant was already behind on rent, that is not a factor in whether or not they can have the plan available to them or whether or not they should be approved for the plan. With this caveat, I think that if the tenant was already behind and there is a judgment for possession, either through a trial or an adversarial proceeding in the landlord-tenant branch, or through some sort of a consent judgment agreement in the landlord-tenant branch, I think we need to carefully evaluate how to handle that case. And I don't think that there is a one-size-fits-all approach to a tenant who has a pending court case that predated the court closure and the pandemic. And then here's a second question: how do landlords get the application? There is no application. The application is something that the landlords have to create. So it can be as simple as a name, an address, an email, a phone number, and a description of the financial hardship, as well as a direction to send in supporting documentation associated with the hardship. But you know, different landlords are asking for different kinds of applications, but it is something that landlords are going to need to create.
Billy, there's a question about enforcement. May I jump in?
Yes, of course.
If a residential tenant believes that he or she has a claim to unfair, improper treatment by a residential landlord on a plan, the tenant's resort for relief would be to the rent administrator within DCDHCD. And then the rent administrator, I believe, under the statute, would refer that matter to the OAH, Office of Administrative Hearings. A commercial tenant's similar claim for relief, reconstitution of a plan, review of a plan, or give me a plan, would then go to DCRA. And my own experience was a complaint lodged to DCRA. They did not know what to do with it. I'm not criticizing them because there's no regs, there's no process, there's no procedure. And then DCRA would then forward it likewise to OAH. And OAH has said, both in the context of relief under the statute equipped and housing cases generally are at the end of the list for purposes of mediation and adjudication. Thank you, Billy.
Of course. All right, and here, who creates the payment plan? Well, the landlord needs to create the payment plan. I mean, one of the things that's a little bit frustrating, I think, for landlords about the statute, and maybe this is more than a little bit frustrating, is that the bill doesn't say what the plan needs to look like. It just says that landlords need to offer a rent payment plan program. It needs to be for 12 months or prior to the cessation of the tenancy. The landlord has to provide notice, but it doesn't provide any real strict guidelines on the framework of the plan. So, I will tell you that, our clients are doing vastly different things. Our clients, some of them are allowing deferrals of entire months of rent. Some of our clients are allowing deferrals based upon, financial statements from tenants. They're asking for a lot of financial information from tenants. Some of our clients are doing something simple like saying, we're going to allow a deferral of 50% of the rent for the months of, June, July, and August. And we're going to start the repayment plan with 50% of rent due for June, and then extend it out 12 months there. So I think that one of the difficulties is the creation of these plans, and we've talked through how to do that with a lot of our clients, and certainly would be happy to talk through it with anyone on the call. I think that sometimes when you get into the weeds on these things, it helps to clarify, what you want to do and how you want to do it. And look, the other thing I think that's happening is that so many landlords are in a position now where they really do want to help their tenants, and they really want to keep these people in these properties for as long as possible, provided that they can pay something, because landlords understand, the difficulty that everyone's experiencing, but also the difficulty in having a vacant unit and trying to get it re-rented right now, which could be substantial depending upon where the unit is and the other particulars. I guess that's the answer on how to create the payment plan. So I've got a question here. If they enter into a payment plan now and default on that plan, do I have to offer them another plan up until October of 2021? Well, here's what we're recommending that you do. And I'm going to just go back a couple of slides, because the second point here, the rent payment program shall permit an eligible tenant to enter into a plan for amounts that come due during the program period. So that's from March 11th forward, and prior to the end of the tenancy. Now, we all know that in DC, tenancies are special, and that tenancies continue on almost as life estates as long as the rent gets paid. But for a lot of those tenancies, there are also terms. And so what we're recommending that you do is you enter into a plan with your tenants for the amounts that come due from the beginning of the program period, so from March 11th forward, until the end of their lease term, because we think that's compliant with the statute, while it also doesn't extend you out well beyond, you can't ever peg the cessation of a tenancy in DC, but the lease term certainly suggests when the parties think that it may end. All right, moving on, and I'll circle back as needed, but moving on, we have residential cleaning. So this most recent bill, the Coronavirus Support Emergency Amendment Act, requires landlords to do what they all have already been doing during the public health emergency, I'm pretty sure, which is, cleaning common areas of housing accommodations on a regular basis, including surfaces that are regularly touched, such as doors, railings, seatings, and the exteriors of mailboxes. Housing accommodation is any building or structure with a residential unit that's not occupied by its owner. And the mayor can promulgate rules to implement this section. So this really is a section that applies to any kind of multi-family housing. So this does not apply if you rent a row house out to a single tenant group, or a single family home out to a number of tenants who are jointly and severally liable to you. This is really meant to make sure that multifamily properties with, mailbox areas and elevators and stairwells and big common areas are receiving additional common area cleaning. All right. Now, one really, really important piece of this legislation is also that it creates a moratorium on eviction filing. This bill amends DC Code Section 161501, which is the basis on which eviction actions are filed, so that it prohibits the filing of actions for eviction during the period of time for which the mayor has declared a public health emergency and for 60 days thereafter. So what does that mean? Well, right now, it means that you cannot file a lawsuit for eviction, an action for possession in the landlord-tenant branch until September the 24th. And Mayor Bowser today indicated she intends to extend the public health emergency to October the 9th, which would mean when she does it that landlords would not be permitted to file an action for possession in the landlord-tenant branch until approximately December the 9th. Just so we're clear, everyone, that means that we're talking about a period of time from about May the 13th, when this provision was first passed into law, until December the 9th, when the District of Columbia City Council has decided that court is closed to a particular segment of the population in DC. Landlords are not permitted to go to court and seek relief from the court for what they would allege would be a breach of the contract they have with their tenant, either failure to pay rent or some other breach of the lease. And Steve will talk a little bit about this as we move through. Actually, I think on the next slide. Let me just go back here. And this moratorium is more restrictive than the CARES Act. The CARES Act prohibited filing for non-payment of rent suits from March 27th through July 27th. We obviously we're about to blow through that here, but it didn't prohibit breach of lease actions. This filing prohibits both breach of lease actions, and this filing prohibition prohibits the filing of both breach of lease actions and non-payment of rent actions. Means that courts are unavailable to landlords until December 9th for any reason. Steve, I don't know if you want to jump in with some possible other avenues.
Well, yes. So we have different categories of cases right now. And those of you properties and you're in the neighborhood and you're on the ground, you know that there are horrible cases where you need to recover possession of a unit because of bad acts or a horrible rent situation. What the court is doing now is slowly opening the ability of certain possession cases to have virtual hearings. And there was a question that was posted a few minutes ago about, well, what sorts of cases are being handled right now? What we're trying to get into the queue are cases for possession. The court is not holding cases for non-payment of rent. So the landlord-tenant court is a bottleneck, either because of the statute or because of which precludes filings, and because of the huge inventory of cases that are on hold. If you look very carefully, and we are still developing this, and it has been received pretty well by the courts. If you look at the statute itself, Billy was right. The statute precludes filings in the landlord-tenant court. And what we are doing now, especially in breach of lease cases, we're being engaged right now to handle cases for possession involving drugs and guns and murder, disruption of life, and breach of the covenant of quiet enjoyment, where we're going to go to the civil division. And we're going to do that with some test cases within the next week or two. And it will provide to us a completely legitimate way of getting into court. And as of this morning, we were looking at a timetable by which a normal landlord-tenant case could be filed 60 days from July, which would be September something. Now with the extension, we believe, to October the 9th, add 60 days for filing is December the 9th. you're not going to get a court date in landlord-tenant court until first quarter of 2021. And so Billy's invitation to me on a protocol to go to the civil division, especially for breach of lease cases, because we are very concerned about your portfolio, the quality of life in your properties. And those of you who know us know that we are going to go to bat for you for purposes, and I'm not trying to sell our firm, but I'm trying to let you know that there are ways properly, legitimately to proceed to recover possession under other statutes and other procedures. And we are making some headway right now in some cases in the civil division.
Yeah, and this is a real good example of one of the great things that Steve brings to the table. He's creative, and he's able to solve problems even when those problems seem unsolvable.
Let me jump in and answer the question that just popped up on our screen. The question from the floor was who's abusive, assaultive, verbally disruptive, threatening, and all that sort of a thing. The tools in the toolbox generally include, if there's a familiar relationship, you can go to intrafamily court, you can go to the division of the court for domestic violence, or you can issue barring notices. What we're trying to do is find other avenues to get someone whose conduct is offensive out of the unit or off the property. So we're also employing more and more barring notices and injunctive relief to have someone barred from or arrested from the property. So what we're trying to do is the enforcement action to the extent that we can to keep someone off the property or in compliant condition.
So the other thing I think that's important to keep in mind with regard to this eviction filing moratorium is there are really two things. So the law as it was passed on May 27th and clarified on June 9th states that its effective date is March the 11th, and that that's the beginning of the public health emergency. And so it appears from all indications we've received that the DC Superior Court's landlord-tenant branch is going to do something called issue a notice to show cause for all of the cases that were filed after March 11th because of this law, and ask landlords to essentially make an argument that the cases shouldn't be dismissed. I think in some cases, landlords will want to make that argument. In other cases, landlords will say, you know what, I'm going to offer this tenant a payment plan anyway. It's not going to be worth it to me to try to make this argument. It's going to be an uphill battle, I think, and it's going to be an argument that I think is probably going to end up going to the Court of Appeals at some point in the near future, and hopefully it'll be a case that gets through the Court of Appeals in a fashion that is aware of how necessary it will be to have a determination on this question.
Well, the question right now, Billy, has been framed by another question from the floor, which alludes to a class action lawsuit. And there is one practice tip, one piece of information, one ask that Billy and I can make right now to you. We are now front and center in having to brief the first notice of a preclusion to do so. And so we've got to respond to show cause orders with the law about whether or not a statute can retroactively affect contract rights or access to the courts. And so it's not so much a class action lawsuit as a smart, constitutionally correct response to the civil division of the court saying why a case filed, and I've got one. Billy and I have one right now. It was filed on March the 11th. It's a woman and her husband who are on diplomatic mission overseas, and they want to move back into their house, and some kid that had squatters moved out and there's squatters there. So it's very important that we have your support if you have Any ideas? I mean, we're supposed to be the legal beagles here, but we have to file the brief, and it's going to be within the next 10 to 15 days. So it will not be a class action suit, but it's got to be a smart brief, because we win one, the civil division is going to apply it to all of them from March the 11th forward.
So, Chris, I'm seeing a lot of questions, and I've got a lot more slides, and it's 6:50. I don't want to go over or step on your toes. I will respond to this question. There are, I think, a lot of different groups in different cities and states that are filing lawsuits in order to prevent laws that have prevented access to the courts from taking effect. Some of those have been successful. Some of those have not been successful. There's one in Baltimore right now in which the landlords actually lost their battle for a temporary restraining order. I do know, however, that a debt collection conglomerate, I think a trade association, filed a successful lawsuit in Boston. Look, I think that this is ripe for a challenge. As Steve indicated, though, we're going to be challenged in a different way by trying to keep the suits that have been filed after March 11th and before May the 13th in play, and not have them dismissed sort of automatically by the court. I have talked to a number of people about filing a federal suit against the District of Columbia and the council in order to have this law, or portions of this law rather, struck down or declared unenforceable. And what it seems like to me so far, and Steve can chime in too, is that no one wants to go first. There are lots of landlords who would like to join, but not lots of landlords who would like to have their name on the lawsuit.
Let me tell you what it's going to take. It's going to take one really smart brief. And lots of small landlords are daunted by the cost, or daunted by the fact, oh, we've got this monolithic court and we've got the legal services providers who have all these smart folks with unlimited resources. It's going to take one or two really smart briefs, and that's where we could use some help.
But let me just sort of try to wrap this up real quick here. And Carissa, certainly, I think I've already shared the PowerPoint, but I can share with you this updated version of it, given the mayor's announcement today. And you can certainly send that out to the group. So tenant deadlines are told during the emergency. If you're charging amenities fees, you may have to refund those if your amenities have been closed. You cannot charge late fees. Any notices to vacate submitted by tenants prior to the beginning of this public health emergency, which would have had them vacating during the emergency, are told until the end of the emergency, which means that if a tenant submitted a notice to vacate in February for March 31st or April 30th, that tenant's going to be able to stay until at least the end of October at this point, after the mayor extends the public health emergency. And then rent increases are prohibited. So any rent increase that would have taken effect after March the 11th, and any rent increase that's been given during this public health emergency, is prohibited. And what we have seen from the rental accommodations division as recently as today is that they are now beginning to go through an enforcement process on all of those rent increase notices for rent controlled properties, and ask landlords to formally rescind those notices and then advise the rental accommodations division about what they've done. So Chris, I'll turn it back over to you so you can wrap things up. I don't want to go on too long. I want to be respectful of everyone's time here on a Wednesday evening.
Thank you so much. Thank you so much for sharing that, Billy. Thank you so much, Mr. Hessler. Your screen is still being shared. Can you see me, guys?
Yes, I will stop sharing. I'm sorry about that.
That's okay. Okay, it looks like, all right, let me do this. It looks like we are viewing Johnny May's. Ms. Johnny May, can you share your screen, please? We are looking at your screen. So at the bottom of your screen, if you're on a computer, Johnny May, you'll see a little green, looks like at the bottom of the screen, you'll see something that says share. If you click to the right of that, does it give you an option to stop sharing? Because we don't need to see what you're sharing on your computer. Not unless you are giving us a presentation, which I was not prepared for this evening. All right, so I do have officials from the DC Housing Authority on the line. I'm going to ask Kirk Batson if he wouldn't mind. Mr. Batson, if you're still on the line, would you unmute yourself, please? I know that there are a lot of questions that you guys have for DC Housing Authority, some questions that have come in regarding landlords and individuals who are not able to get a response from officials at the DC Housing Authority. Mr. Kirk Batson, would you address that for us on this evening? And if he's not on, Nathaniel, if you're still on, if you wouldn't mind answer that question for me.
Can you see me?
I can see you, yes.
Okay. To address that problem, we have had major technical difficulties getting back up to full capacity of work, but things have actually gotten better. We have our call center staff that have returned. So the 202-535-1000 number is up and operating. And what is happening is they are actually sending the calls that come through to the prospective departments and department heads. So things should be getting better as time goes along. It's just been some glitches with some technical glitches. We have been issued new computers, so everybody's getting acclimated to these new laptops. And there have been some glitches with programs on the laptops, but things are actually starting to work a little better.
Okay, thank you so much for that. And I know, Mr. Batson, you and I, we've had a conversation in the past about the tenant's ability to transfer. And I know that some landlords do have questions because there are tenants who are looking to transfer to other units. How are you guys handling transfers during this time?
So right now, we aren't doing any transfer briefings, and that isn't a decision by DC Housing. That was actually a HUD decision because of the COVID crisis. They wanted to slow down that process and not have people out and about. And right now, we haven't gotten word when we're actually going to be starting that back up. And as far as people transferring, we tell them in their initial briefing that they should not start that process until they actually have voucher in hand. So a lot of people have taken it upon themselves to really get out there and start looking, which is really messing themselves up and then putting themselves in the wrong position by doing that before they actually have their vouchers.
Okay, thank you so much for that. Okay, so Mr. Kirk Batson, I'm working with some clients of mine, some colleagues of mine. We have over 100 vacant units that we're trying to fill. How do we fill our vacant units, and how do we get our units into the eyes and the homes of voucher participants who may have previously had a voucher before the start of the pandemic and maybe out on the street searching for rental property?
Well, if you do have listings, you can actually send those to me by email. We have a system in which is going to be activated soon to actually allow you, as we had before the unit portal, they're just doing upgrades to the unit portal to allow you to upload your information about your units. And the way they're working that system, it's actually going to give us the ability to provide those participants, once we do start those briefings again, lists of units in their areas that they're requesting once they've completed the briefing at that time, while they're still actually, they won't walk away without the listings at the present time.
Okay. Okay, and so that was Mr. Batson. He is an official with the DC Housing Authority. Do you have any questions for Mr. Batson while we do have him on the line? I know that you guys have had complaints and concerns of not reaching people at the DC Housing Authority. They are here now, and I just want to be respectful of their time. So if you have questions for them, go ahead and drop your question or your comment in the chat box at this time.
I do want to say that our staff was limited during the beginning of the COVID crisis. So a lot of people were not communicating or receiving communication at the time because we didn't have all our specialists working. The capacity of people that were working was very small. So we were responding as quickly as possible to all the people we could. But we are fully staffed now. The staff have new systems that actually will enhance and make their jobs better to actually assist.
Okay. Okay. Thank you so much for that. And do you know, I have a question. I have individuals, I have also tenants that are tuned in live on Facebook. And so one of the questions that have come in, Mr. Batson, is they're asking, do you know, or do you have an idea when briefings will resume? Because this particular person, her appointment was canceled in April.
I do not. But what's going to happen is once we do resume, we are going to go back to the scheduled appointments and take care of those people first. So they don't have to worry. If they were scheduled, we're going to go back to the official date that we were out of work and start going forward from there.
Okay. Okay.
So they would be the first to get their vouchers.
Okay. So the ones who previously had the briefing will be the first to get a new briefing.
Correct.
Okay. All right. So, Mr. Bass, can you take a look at the chat box? There are some questions that are coming in. And while you're doing that, I have a question for the attorneys. Billy, I have a question. So we had for instance, we had an agreement with the tenant, a settlement agreement that they were going to move out, let's say by February the 28th, or maybe March the 3rd, right before the pandemic hit. The tenant was supposed to vacate the property. We had already gone to court. We did the settlement agreement through the court. So now we're in COVID-19. The state of emergency has been extended through October. So at this point, what do we do now? Do we have to go back to court? Do we have to do a new agreement? Would the courts allow us to, would the court grant us a writ so that we can evict the tenant? What will we do in this situation?
Well, I think Carissa, that you would go back to court. So if you have a court agreement that was approved by a judge, then what you're going to be doing if the tenant was supposed to vacate by a particular date and has not complied with the agreement is you're going to file a motion to enforce that agreement, and you're going to ask the court for whatever remedy is set forth in the agreement. I would think that if you have such an agreement, that your remedy would be that you're able to obtain a non-redeemable judgment for possession. Now, you might be able to obtain that judgment for possession, but as you correctly indicate, you're not going to be able to get the eviction. And you won't be able to get the eviction until probably, I hate to say this, but probably until 2021. Because if the eviction moratorium exists 60 days beyond the public health emergency, that's December the 9th. And then, as you know, we're going to have to issue a 21-day notice. We're going to have, a long wait.
Okay. I don't understand this at all.
Okay, Ms. Johnny Mae, do you have a question?
Yeah, I wondered if he had a chance to look at what we sent about the case in Cincinnati.
Okay.
Where they were able to take a lawsuit and change it, and they did it within a month's time. It was an emergency, and my niece got her person out within a month.
Well, ma'am, I'm not aware of that particular lawsuit. I did see that you posted it. I'm going to look into it. I think that, as I said, I think that these are very fact-specific cases. And,
No, they made
know-
a general, it was a general thing. So in Cincinnati and in Hamilton County, they no longer can keep people who are having problems with tenants out of the courts.
Right. But I think that a lot of that has to do with the laws in Cincinnati.
Right.
So, we would need to
true.
bring an action here based upon the laws that have
Here.
been enacted in DC.
I do understand that, but they aren't that different. I'm from Cincinnati. I know they're not that different. So I think we need to look into it anyway. Because it's a
Well,
very,
like I said,
very
we
interesting case.
need someone who's willing to be the plaintiff.
I don't mind being a plaintiff because I'm tired of my property being destroyed. No, I don't care if it costs something. I'm tired of my tenant tearing up my property.
Lawyers charge too much.
Guy,
Listen,
hush.
I understand that all too well, Ms. Durant. I promise you, I have a list of tenants. I probably have at least 75 tenants that I can't wait to get into the courts. And of course, I have a heart for the people, but I agree with you. But unfortunately, jurisdictions are different, and that's one of the things that I share, in the group. What applies in Cincinnati doesn't apply in DC. So for instance, in Mount Rainier, Maryland. So check this, in Mount Rainier, Maryland, I read something, guys. I'm not sure if you're aware, maybe you don't even care, but in Mount Rainier, one thing that they're trying to impose on those landlords is that those landlords are being asked to enter into a 3-year repayment agreement with their tenants, or allow their tenants to up to 3 years to repay money that's owed. So, what works in one area doesn't work in this one. And so I don't really want to waste a lot of time with the back and forth on that, if that's okay.
I understand that completely, but nope. If you don't try, you will never have it. You at least
right,
you
but I don't
try.
think, yeah, but realistically, Miss Johnny Mae, I don't think we can resolve that on this Zoom, because we're talking
And
about law.
it depends on what it is. I mean, we have somebody who's almost
move on,
burning
please?
down our property. That's an emergency.
I get it, but we can't, what I'm saying is we can't resolve it, and I have a heart, I hear what you're saying.
No, I know we can't.
We
I'm
can't
just
resolve
saying,
it on the Zoom, but.
and I do understand that. I know
Okay.
but I'm just throwing it out there for you to realize that this is something that needs to be done. And I personally am not opposed to doing it myself, but it would be nice if we do it to have the backing of the other people who also are having similar problems, so that it's not just one person having a problem.
Okay.
Because all of us, I'm sure, are having that problem.
Yeah, I'm sure we're going to have more problems, because the attorneys just told us tonight that, and I was aware that the state of emergency was extended in the District of Columbia through October, so it doesn't make me feel well, but we can definitely revisit this. Are there any other questions at this time for either the attorneys or officials from the DC Housing Authority?
Reading a question, someone wants to know what my role is. I am the relocation, orientation, training, and counseling supervisor. So I'm over the department that issues the vouchers. I am customer relations over the Housing Choice Voucher Program. I assist in many different areas. I guess you can kind of say I'm the go-to person when it comes to DC Housing Authority. I try my best to assist in any way I can. So if that helps you. And I see another question, if the HAP contract is terminated due to fire. I'm not sure what you're asking. If your HAP contract is terminated due to fire, you would have to actually get your unit back up to code. And then you can petition for an inspection if you're going to put the tenant back into your property.
And what if we don't want to put them back in there?
That's your choice.
And consequently, we don't even do anything to the property because it's got the fire.
Well, if it had a fire and the tenant is no longer in there, the HAP contract is canceled.
Yeah, that's fine.
Hi, Carissa.
Yes, I'm here.
I have a question. So, I have a couple of empty units. People are inquiring about it. They want to move in, but I'm not going to rent because I can't raise, even if I get a Section 8 tenant, the way I read the law, it says you cannot raise your rent, not a dollar, not a penny or anything for any reason. It's a silly law. I mean, I don't think they thought about it, but I'm asking the lawyers, is that true that I can't put a Section 8 tenant in there who's out from under rent control?
No, that's not true.
Okay.
That's not true. So if your property is a Section 8 property, it's exempt from rent control.
No, it's not a Section 8 property. It's just that some of my tenants are Section 8.
Right. So the second that you enter into a HAP contract with DCHA and you bring in a tenant who's a participant in the HCVP program, your property is exempt from rent control.
Yes, but
so
what about the
it's
law that they just made? Am I exempt from that?
Sure. So right now your property is vacant.
Yes.
Yeah. So you're not increasing the rent on any tenant right now.
I'm increasing the rent on that unit though. Rent control keeps track of what my last rent was. I want to increase it by $50, not much, $100, not much. But
so it
said no increase in rent, period, right? Isn't that what the law says?
So the property is rent controlled?
No. I mean, yes, my whole property is under rent control, yes.
Okay, well then yeah, there's no rent increase. But that's because the property is rent controlled. If the property were market rate unit or exempt from rent control, you'd be able to increase it at vacancy.
Well, okay, so our whole property is under rent control because it's, old, 1960. But the minute I enter into an agreement, a HAP contract, I'm out from under rent control. I can raise it to whatever Section 8 will pay. Normally, that's the normal circumstances. But with this law, I believe it says you cannot raise the rent for any reason. I don't care about rent control, Section 8, nothing. Is that true? That's the way I
don't read the law to prohibit a rent increase from a vacant unit at an exempt property. I think that you're caught between a rock and a hard place because your property is rent controlled, and it really only becomes exempt when you bring in a tenant who is a participant in the HCVP program, right? So I think you're caught because you're going to have to file with RAD and they're going to reject any rent increase.
This is Steve. This is Steve Hessler. Let me jump in. I think the real question is whether the language of the statute applies to a person or a unit. And I think the statutory intent is that you don't raise rents on a person during COVID. But if you're going from vacant to occupied, you're not raising the rent as to a person. You're increasing the ceiling, or you're collecting rent that is divorced from any particular person. I would say you pass go.
Okay. So I think I can file with the rent administrator's office that there's an increase in rent. They just put the stuff they just file it. They don't really do anything about it. They don't contact the tenant and say, your rent's going up. They just file it.
Well, they're gonna contact you.
Yeah.
If you file for a rent increase and the rent increase is implemented at a time when the public health emergency is in effect, they're eventually going to get to you. We had a client today who got notice from them earlier this week, or last week rather, for a December 2019 filing for a rent increase implemented April 1st of 2020. So I don't know this for a fact, but I assume that what's happening at RAD is that under the enforcement provision of the Coronavirus Support Emergency Amendment Act, they're going through rent increase notices and they're pulling the ones that are applicable and they're reaching out. This notice said to our client, you need to rescind this rent increase and you need to send us a letter which says that you did it.
Is that what they said to your client?
Yes.
Okay. All right. That's wrong.
And 7 days to come into compliance.
But you think it will matter for the vacant unit that you fill after the emergency?
I think it's yes. I think that the notice from the rent administrator specifically said that, in fact, that vacancy increases. And I think that the reason for my guidance between the difference between market rate and vacant and rent controlled units is that for market rate units, you're just advertising, as Steve said, you're not increasing the rent on a person, you're increasing the rent on a unit. But for rent-controlled properties, while you still may be doing that, you have to file the rent increase with the
Right.
city. And they've been given an enforcement mandate from this law, which basically tells them not to allow that.
So you think that's something maybe we should just contact, the people at city council and say, look, adjust this. I mean, it's common sense. You don't want, because I leave it empty. I'll let it sit empty and you can have more homeless people. I don't want to be that landlord, but I'll do that if that's what they force me to do.
Look, I would highly recommend contacting your council member. I think that, the mayor didn't say this today, but I believe that the mayor feels like she's a little bit hamstrung with all of these different deadlines tied to the public health emergency. I think for a lot of reasons, the mayor needs to keep the public health emergency in place. A lot of legitimate reasons that have nothing to do with these laws. And the council has linked up a lot of laws to this public health emergency, which do things like this, like freeze rent increases, like make the courts inaccessible, like make debt collection not a possibility. I think that the city is going to get choked economically for far longer than it needs to, because of the way these laws have been written and tied to the emergency.
Thank you.
Is there a deadline to notify the tenant of this payment plan?
There's nothing in the statute, but like I said, I think that we're at the point now where you should really be getting that notice out. And again, I don't think that there's necessarily any sort of like urgent pressing eviction pressure or anything like that. But, I think that from a landlord's perspective, you want to get on that 12-month payment plan with your tenant sooner rather than later. You want to get that going. Number one, it may mean that you collect a little bit more rent than you might otherwise. And number two, the sooner you get on it, the sooner it ends.
I'm sorry. So yes, that was my question earlier. I'm not sure you kind of answered it, but so if I get on a payment plan with them now and 3 months later they default, are they done or can they just get on another plan later?
They should be done. I mean, I think if you create a plan that takes into account all of the rent coming due from the emergency period to the cessation of their tenancy, you're giving them one plan for all that rent. Now, under the Trans-Lux doctrine, I mean, they'd still have the opportunity to catch up, and it sounds like, based upon what we're seeing from the mayor and others, they're going to have an awful lot of time to do that, before you could possibly evict them. But I would not recommend entering into a plan that requires you to go back to them on a monthly basis and enter into new plans every single month. I would enter into one plan with them for all of that rent and then have that be the plan.
So you can imagine that I have a lot of tenants, and I have tenants who are on, their year is up and they're on month to month forever, and that's fine. But so the cessation of their lease term would be 30 days?
2 weeks.
Yeah.
Look, I think that, this is a good example of a hastily written law, and one of the interstices, right, is this month-to-month tenancy. I don't know, the cessation of tenancy language, while it's potentially helpful for some landlords who have tenants on 12-month terms, it certainly leaves landlords like yourselves whose tenants have renewed on a month-to-month basis, probably for long periods of time, in a difficult position. So you may make a decision to say, I'm going to offer you a 12-month plan for 12 months of rent, or for 6 months of rent, or something like that. But either way, anything you offer them over and above the cessation of their tenancy, I think is in excess of what the law requires. But I agree with you. What the law requires in your case is silly.
Okay. Thank you.
Hey, Mr. Batson, are you still there? I have a question from a Facebook viewer pertaining to a new move-in that just took place in July, where the elderly voucher participant, their family is stating that the property does not meet code housing, the housing quality standard. So it sounds like maybe a virtual inspection was done and that this family has not been able to reach individuals at the DC Housing Authority. How do I direct them? Who do they speak to, Mr. Batson or Nathaniel Nat, if you're still on the Zoom?
I'm here. So they're saying that it failed inspection?
No, it obviously passed inspection, but there's still a lot of issues. So it looks like maybe something was overlooked, but they've not been able to reach anyone. It's an elderly lady. She's a voucher holder. She's in a wheelchair, but they've not been able to reach anybody at the housing authority. So who would they contact?
They can send an email to me. My email address is my last name Batson, BATSON, at dchousing.org.
Okay. All right. Thank you so much for that. All right, guys. All right, go ahead. Mr. Batson, were you finished?
Yes.
Okay.
Once they send that email, I'll respond to the email.
Okay. So what we will do is we are definitely going to have minutes and notes from this this session tonight. We are definitely going to email them. Rashonda Joseph, she is the secretary for the DC Housing Providers Association. For those of you who don't know, I'm Carissa Spann. I'm the chair for the board chair for the DC Housing Providers Association. Since we are no longer able to meet each month at the DC Housing Authority, we will continue to have these discussions online by way of Zoom. Any information that I can bring that would be helpful to you all, this is what I am privileged and honored to do. I thank the attorneys. Thank you so much, Billy. Thank you, Mr. Hessler. Thank you, Mr. Batson, for joining us on this evening. In addition to this Zoom, we have Facebook Live that's going on. We have tenants and landlords who have been asking questions. And so this is what we do. We have to come together as a community. It's not just, you know, housing providers who are impacted by the state of emergency.
Can't hear you, Carissa.
If you know of resources that can help these tenants, go ahead and do that. And, you know, sometimes it may not make sense to help tenants who's not paying, but at the end of the day, if we can help these residents, if we can help these families to go out and secure finances or money or resources that's available in the community, if we can help them to get the money that's going to pay the rent, then it just makes sense to have a heart and give the tenants this information. So again, thank you so much, guys, for tuning in. We would definitely send out the information. I did have a couple of questions pertaining to what I do outside of the DC Housing Providers Association. A lot of you do know that I teach property management at one of the local universities here as an adjunct professor, but I have also created a 6-week online course that will help landlords and housing providers understand the role that you play, understanding the importance of how to attract your ideal tenant. So if you have questions about anything that you heard today, you have contact numbers and information, you can always email me. If you are not on my email list that I send out each month for these meetings, please inbox me. Let me give you my email address right now. I'll also type it in the chat box. My email address is carissa@dchpa.org. My email address again is Carissa, KARISSA @dchpa.org. If you have any questions, any comments or concerns, if you're not able to reach individuals at the DC Housing Authority, if you need attorney help or assistance, I'm here to provide resources. If I don't have the answers, I will definitely get it for you. If you're interested in more help and more training, the course that I've created, or any questions pertaining to being a housing provider in the District of Columbia, please let me know. And again, if I don't have the information, I will definitely get it to you. Our time is up, and we definitely thank you for yours. This session was recorded today, so we're going to get this out. We're going to get the minutes out, and we're also going to get the PowerPoint presentation that was shared today by the attorneys. We're going to get that out to you as well. So before we conclude, do we have any other last-minute questions or comments? I do see some of my students on the line, so I just want to say thank you so much, and I hope that everybody's doing well. These are tough times for everybody, guys. All right, I also want to acknowledge a few board members. I see the email address. So guys, check the chat box. That's the email address for the attorneys who gave the presentation on tonight. They are available, they are willing, they are able, they are capable to assist you. I want to acknowledge a few board members who are here. Johnny Mae Durant, that's one of the individuals who had questions on this evening. She's a board member. I see Russ Brown. He's a longtime board member. He's back to help us out. Thank you so much, Russ, for being on the Zoom call tonight. Russ, do you want to address the people on this evening?
No, well, I thought this was a very informative meeting. I really appreciate everybody for coming out and being respectful. Mr. Batson, I appreciate you giving out your information. I know in the last meeting, Mr. Batson, you gave a phone number out for people to reach you. Is that still available?
Yes, sir. It is still available.
Okay. All right. Cool. Sounds good. All right.
Thank you so much for that, Russ. Rashonda, are you on the Zoom? Are you still on the call, Rashonda?
You know Rashawn is not going to say anything.
Okay. All right. So with that being said, do we have any other questions from any of you before we? Okay. So Rashonda is here, but she's not going to say anything. So guys, does anybody have any other questions or comments before we conclude? No other questions?
My name is Mr. Terrell, and I'm so sorry for coming in late. I don't want to delay the process. Just a very quick question. If in general you've had somebody already went through the court system and they were set to leave and COVID took over, is that still precedent, or you just have to wait through it?
It's probably something you can move toward obtaining the relief, but I think you're probably going to have to wait for the eviction. So if what we're talking about is an eviction, you're probably going to have to wait until probably the beginning of next year at the earliest.
Roger all. Thank you.
Okay.
Ms. Spann, can you hear me?
Yes, we can hear you.
Is there a link to the recordings and minutes of prior HPA meetings that have occurred since the pandemic began?
Well, this is actually our first recorded, but I can definitely forward you. I will forward you the minutes from our last meeting, and moving forward, we will always record. We will always send out minutes. And so again, if you are not on my email list, please definitely email me to make sure that we add you to the listserv, to make sure that you're kept in the loop of what's happening and the changes that are taking place. And guys, if any of you are on Facebook, please find me on Facebook on Mondays. I do a Facebook Live every Monday at 7 p.m. Eastern Standard Time, from 7 p.m. to 7:30 p.m. I'm giving information that helps landlords. So it's pretty much an abbreviated session of today. And so that's each and every Monday. Again, my email address is carissa@dchpa.org. All right, so let me give you the date of our next session. Is always the third Wednesday of the month. So our next Deep Housing Providers Association meeting is going to be Wednesday, August the 19th. It's going to be at 6:00 p.m. We typically go from 6 to 7. We went a little longer on this evening but that's quite all right because we were receiving so much information and there were a lot of questions. And so, again, I do thank you all for your time. If there are no more questions, we are going to conclude the session for today. If you know you're not on my email list, email me in order to get this information, okay? Mr. Hessler, did you have any last comments you wanted to share?
Call us, we're here. We're happy to help. And we make house calls sometimes. We socially distance, but we visit our properties and we're here to help you out if we can.
Great, thank you so much for that. All right, guys, well, you have a great evening and continue to be safe during this COVID-19 season that we're all faced with. Thank you again.
Thank you, everyone.